Wilson. Can I have parties announced for the record? State.
Right from the start, this case drops us into the deep end. Multiple suspects, a double homicide, and a young man suddenly facing the full weight of the criminal justice system. And here's what immediately stands out. This isn't just about one incident. This case quickly reveals itself as part of a much larger chain of violent events, intertwined with other investigations, other defendants, and escalating consequences. Today, we're breaking down what really happened in court, step by step. We'll look at how plea deals work, what deferred adjudication actually means, why judges sometimes reject probation even when families beg for leniency, and how one defendant's decisions inside and outside the courtroom completely changed his legal fate. You'll see moments where defense attorneys try to paint a picture of a young man caught in the wrong place at the wrong time, and then watch as the judge challenges that narrative head on. We'll also unpack how courtroom decisions aren't just about sympathy. They're about accountability, safety, and whether someone truly understands the gravity of their choices. And here's the big question we want you thinking about as we move forward. When does "I was just with the wrong people" stop being an excuse and start becoming a personal responsibility?
Arriola.
Defense.
Written error for Mr. Wilson.
And are you Mr. Wilson?
Yes, ma'am.
And cause number ending in 27B. You're charged with deadly conduct, discharging a firearm in count 1 and count 2. Is that correct, state and defense?
That's correct, Judge. Yes, Judge.
All right. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. And the cause number ending in 28B. You're charged with the offense of aggravated assault with a deadly weapon. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If the court were to grant your application for deferred adjudication in that cause number, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
Let's pause here because this section is packed with legal meaning that moves quickly in court but carries enormous consequences for the defendant. The judge is outlining punishment ranges for multiple felony charges. Notice how the sentencing exposure stacks. Deadly conduct with a firearm carries years in prison, aggravated assault with a deadly weapon carries even more, and fines are layered on top. But the key phrase here is concurrent sentencing. And that means if Wilson were sentenced under this plea, he would serve the sentences at the same time rather than back to back, which significantly reduces total time behind bars. Then comes something crucial: deferred adjudication. That's essentially probation, where the court delays a formal finding of guilt. If the defendant successfully completes probation, there may be no final conviction. But if probation is violated, the judge can impose the full prison sentence. And notice something important. The state is opposing deferred adjudication, meaning prosecutors believe probation is not appropriate given the severity of the case. Here's something to think about. If someone is connected to a shooting that ends in deaths, should probation even be an option, or should prison be automatic? Drop your thoughts as we continue, because this tension drives everything that follows.
According to your plea bargain agreement, the cases are to run concurrently. The state is taking in consideration 2024 CR 3009, County Court Cause number 732604. And in the plea bargain agreement ending in 27B, state is proceeding on counts 1 and 2. Punishments be assessed at a cap of 10 years in the prison. There's a $2,000 fine. There is affirmative finding of deadly weapon, and the state is opposed to your application for deferred adjudication. There's to be restitution, if any, to the complainants. And then in the cause number ending in 28B, there's a cap of 12 in the prison. There's a $2,000 fine, affirmative finding of deadly weapon. State opposes your application. There's to be restitution, if any, to the complainant. Did you understand that to be the plea bargain agreement in each cause number?
Yes, ma'am.
Then in cause number ending in 27B, how do you plead to count 1? Guilty, not guilty, or no contest?
Okay, no contest.
Count 2, how do you plea?
No contest.
And in the cause number ending in 28B, how do you plea?
No contest. No contest.
State any evidence.
For each case, the state offers State's Exhibit 1 with attachments. We've reviewed them and have no objection.
In each cause number, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. We're going to come back on December 19th. I'm going to ask for a PSI TAP evaluation. On the 19th, I'll review whatever evidence is presented to me and make a decision on your application.
Yes.
All right, is there anything else from either side?
No, Your Honor.
Nothing from the defense.
This is where the defense does what defense attorneys are supposed to do: humanize the defendant. They're presenting Wilson as a young man who fell into bad company, someone who has potential, plans, and family support. Notice the strategy: youth, education completion, future job plans, business ambitions. All signals meant to tell the judge, this person can still become productive if given another chance. Letters of support from family, teachers, and relatives reinforce that message. Judges see these often, and they matter, but only if the defendant shows true responsibility. The defense is basically saying prison would destroy future opportunity, while probation could redirect his life. But here's where things get complicated. Courts don't just look at future promise, they examine present accountability. So here's the engagement question. Do you think being young and influenced by others should reduce punishment when violent crime is involved? Or should consequences stay the same regardless of age? Because in just moments, the judge reveals a major concern about Wilson's attitude. And that changes everything.
Versus Curtis Ray Wilson. Can I have parties announced for the record for the state
Andrew Harris, Salem.
defense?
Bud Rittenhour for the defense.
And are you Curtis Wilson?
Yes, ma'am.
All right, you entered a plea on November 7th to aggravated assault with a deadly weapon. According to the plea bargaining agreement, punishment is to be assessed at a cap of 12 years in the prison. There's a $2,000 fine, affirmative finding of deadly weapon. State opposes your application for deferred adjudication. This will run concurrent with 2024 CR 2927B. And the state is taking into consideration some cases. All right, and also 2024 CR 2927B. And that cause number, you entered pleas to count 1 and count 2. The state waived count 3. And that's a deadly conduct discharge of a firearm. And according to that plea bargain agreement, punishment is to be assessed at a cap of 10 years. And it's to run concurrent with 2024 CR 2928B. And there are 2 other cases that are being taken in consideration. Any witnesses, state?
No, Your Honor.
Defense, any witnesses?
That we have none to testify. I provided the court a motion I filed this morning with statements from members of the family. We do have 3 members of the mother, father, and stepfather are present in court in support. They're not asking to testify.
All right, any objection to the court reviewing the letters of support?
No, Your Honor.
All right, just give me a moment. Let me review that. And the letters of support are from the defendant's father, former teacher, cousin, stepfather, and mother.
That's correct.
All right, the court has reviewed the letters. All right, defense.
Obviously, we're asking for the deferred adjudication, Judge. We'll get here in both cases by law of parties and not by direct action by him. Mr. Wilson was 19 years old. In fact, he turned 22 months ago at the time of this offense. He has graduated from high school, actually withdrew from Sam Houston, finished it online, home tutored by his mother. He had just gotten with the wrong people, going places, not questioning where he was going. He and I have talked a great deal since he's been incarcerated. He understands that you can't just pick up with people and go and not ask what's going on. He has some positive plans as
This is the turning point, and you can feel the temperature in the courtroom shift. Judge Boyd isn't focusing on sympathy anymore. She's focusing on responsibility. And her issue is crystal clear. Wilson keeps saying he got caught up, but never says, I made the decision. In criminal court, ownership matters. Judges often see defendants minimize involvement, blaming friends, circumstances, or confusion. But from the court's perspective, Choosing to ride along with armed individuals heading into confrontation is itself a choice. And the judge points out a logical gap. If someone is wearing masks, moving between cars, and weapons are present, how do you not realize something serious is about to happen? This isn't just legal analysis, it's psychological. The judge is trying to determine whether Wilson has learned anything or whether he's likely to repeat dangerous behavior. So here's the big question for you. Is going along with armed friends just being naive, or does it make you equally responsible for what happens next? The judge's patience is wearing thin, and the next decision escalates things fast.
Indicated by the letters for his future. The young man has a good head on his shoulders and a good positive attitude and definite plans for the future. Sending him to prison at this point in his life is certainly not going to do anything for him or society. Giving him a chance on deferred, understanding the full weight of the punishment is pending over his head should he not make it. He's motivated to finish that, get out there, get training, and just become a productive member of society. He intends eventually to own his own business, looking at truck driving and some other things. So he's looking at the future. He's had a lot of contemplation since he's been in custody. He certainly does not apologize, is not the right word. He's almost ashamed that he was involved in this thing at the scene. He was a passenger in a vehicle. He knows he shouldn't have been there. We're asking for the court to give him a chance.
Okay, the defense is saying that he did not know what was going on or what was going to happen. Do you have any response for that?
This moment might seem procedural, but it's huge. Wilson withdraws the plea and opts for trial. Why? Because the judge just signaled she's unlikely to grant probation. So instead of accepting a plea deal with prison caps, the defense rolls the dice with a jury. But trials are risky. Plea deals offer certainty, trials offer possibility, but also potential for harsher punishment if convicted. This is classic courtroom strategy. When negotiations break down, the case heads to trial. And think about this. Would you risk trial hoping for freedom, or take a guaranteed sentence you know you'll survive? What happens next, though, completely derails Wilson's position in court.
This. Everybody makes mistakes. You make a mistake, don't do it again. I got caught up with something because I was with other people. Well, Mr. Wilson doesn't actually acknowledge what mistake it is that he has made. And as far as I can tell, abdicates responsibility for the choices that he made. He got caught up with something because he was with other people. Not, he chose to be with those people. He chose to do what they did. He got caught up. As far as I can tell, Mr. Wilson still refuses to take responsibility for his choices. And as long as he's going to refuse to take responsibility, he belongs in prison.
All right, so I'm reviewing the facts of the case, and in the facts of the case, it says that they were, the person identified him because they knew him from school. He identified which position he was in, and that a person went in with a mask on. So at what point are you not aware of what people are doing? That's what I'm trying to figure out.
The question was about what was going to happen, what was happening at the time when everything is happening. Well, he was with the people. They were going to do something. He went along with them. His mistake was not understanding what was going on, not asking questions about what's going to happen.
So he's saying that
When people, actually there were multiple cars involved in this case. The one that he was in didn't have anybody in a mask. That came out of a different car. He never left the vehicle. He didn't have a firearm.
All right, if he's saying he didn't know about,
Arguing about whether or not the other people had firearms or not in that vehicle.
all right, if he's saying he didn't know about this plan and he wants a jury trial, I'll give him a jury trial. But based upon what I'm reading in the reports, I don't think he's a good candidate for probation.
Let me talk to my client.
Sure. All right. So what is it? Just a second. We're back on the record in 2024 CR 2927B and 2024 CR 2928B. Defense, did you have a chance to confer with your client?
I have, Your Honor, and given the choices we have, we'd ask that we'd like to withdraw the plea and get trial setting.
All right, Ms. Ferguson, can I have a jury trial setting on Wilson? State, how long do you expect this trial to last?
4 days.
All right.
You can do March 4th.
All right, just stand and let me know you're here. Otherwise, I'm going to assume you're not here and a warrant may be issued for you.
And this is the jaw-dropping moment. After securing a trial date, Wilson leaves the building and misses his own docket call. Whether misunderstanding or poor judgment, the result is immediate. The judge issues a warrant and revokes bond. In court, presence matters. Missing court signals unreliability, and judges have little tolerance for it, especially in violent felony cases. So just when Wilson had a chance to fight his case, his credibility collapses in seconds. Engagement question. Do you think missing court should automatically land someone back in jail, or should there be more leniency for mistakes? Because now, Wilson's legal position just got dramatically worse, and we're about to see how deep this situation actually goes in the larger investigation.
Your arrest.
Require us to whereabouts.
Thank you. Curtis Ray Wilson. Not even here to hear it. All right, is there anyone who came in later? Your name was not called. All right, everyone, these are the rules. Please follow these rules. For the people in the audience, you are not allowed to speak to any of the inmates for security reasons. If you speak to them, you're just going to be tapped on your shoulder and the deputy is going to ask you to leave. And you will not be. All right, who's here on Curtis Wilson? All right, where's Mr. Wilson?
State tells me he has left the building.
All right, so I'm going to issue a warrant for his arrest.
Judge, I'm asking that he be remanded without bond.
I'm going to issue a judge's warrant and remand him without bond. And we're going to go on the record. Court is calling 2024 CR 2927B, 2024 CR 2928B, 2024 CR 3099, State versus Curtis Wilson. Can I have parties announced?
Megan Galloway for the state.
Blood written hour for Mr. Wilson.
All right, this hearing is scheduled at 9 a.m. I did notate that I saw Mr. Wilson in the courtroom. Did he show up for court today, counsel?
He did, Judge.
All right. And Deputy, could you make an announcement for Curtis Wilson in the hallway, please? All right, thank you. All right, defense, do you know where your client is?
Do not, Your Honor.
All right, state.
Your Honor, I'm asking that the court issue a judge's warrant and remand the defendant without bond.
All right, the court will issue a judge's warrant in each cause number and remand your client without bond. And the court did today receive a violation report. Counsel, have you had a chance to review that?
Given to us about an hour ago, Judge.
All right. All right, thank you.
Thank you, Judge.
Sure.
Well, it's still unclear tonight what led up to that shooting or why those suspects opened fire on those two teens. But we do know how investigators were able to figure out the names of those suspects. San Antonio police say they got a call for a shooting around 11 a.m. on Sunday, September 18th. When officers got to the Owlsbury Farms apartments, they found 17-year-old Devin Taylor and 16-year-old Omar Neal still in their car. Both had been shot multiple times. They were rushed to the hospital, but neither one survived their injuries. According to an arrest warrant, witnesses told police they saw at least 3 people running from the scene of the shooting. Also at the scene, investigators found shell casings and a stolen vehicle that had been hit with gunfire. Through video captured at the apartment complex, investigators say they saw 3 suspects at the complex passing through the gate at the same time as Cantu and Neal. That's when an exchange of shots were fired, but police say an Amazon truck blocked the view of the entire incident. They later figured out through other surveillance video the 3 suspects had ditched their car at a nearby gas station. SAPD released video of the suspects going into that store. Moments later, another car comes to pick them up and they got away. After that video was released, a few people came forward identifying the suspects. Curtis Ray Wilson was arrested yesterday and still in jail tonight. His bond set at $500,000. According to that arrest warrant, 2 other suspects have been named in connection to this shooting. One, a 19-year-old man, the other only listed as a juvenile. We weren't able to confirm with SAPD if either one has yet been arrested. As soon as we have an update, we'll post that on KENS 5.
This sentencing gives us a powerful comparison point in the case. Joe Giannis accepts a plea deal, and the judge follows the negotiated agreement. 16 years in prison, with sentences running concurrently. No prolonged courtroom fight, no uncertainty, just a finalized outcome. Notice how smoothly this portion proceeds compared to Wilson's hearing. That's because Giannis accepts responsibility under the plea arrangement and moves directly into sentencing. The judge's role shifts here too. Instead of questioning accountability, she focuses on rehabilitation, encouraging education, job skills, and life improvement during incarceration. Judges often use sentencing moments to remind young defendants that prison doesn't have to define their entire future. But let's be real, 16 years is life-changing. For a 20-year-old, that's essentially the rest of their youth spent behind bars. So here's the engagement question. Is a long prison sentence the best way to prevent future violence, or should courts invest more in rehabilitation alternatives? And just when it seems this case couldn't expand any further, the investigation timeline reveals even deeper connections.
Court is calling 2024 CR 2930 and 2024 CR 2928A. Could I have parties announced for the record for the state?
Jason Garrett.
Defense?
Melissa Christian.
And are you Mr. Yanes?
Yes, ma'am.
Counsel, have you received all of the discovery and did you review it with your client? And the cause number ending in 2928, you're charged with the offense of aggravated assault with a deadly weapon. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. And the cause number ending in 2930, you're charged with aggravated robbery. That's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
In each case, punishment is to be assessed at 16 years in the prison. There's an affirmative finding of deadly weapon. There are no applications. The causes will run concurrently with each other and also concurrently with 723230. The state will take in consideration 2024 CR 2930. And in the cause number ending in 2928A, you agree and confess, judicially confess that you committed these acts with Curtis Wilson. Did you understand that to be your plea?
Yes,
And in
ma'am.
the cause number ending in 2930, how do you plead? Guilty, not guilty, or no contest?
No contest.
And the cause number ending in 2928A, how do you plead? Guilty, not guilty, or no contest?
No
Are you
contest.
proceeding with sentencing?
We are.
Anything you wish to say on behalf of your client?
Judge, we've thoroughly gone over the paperwork, and Mr. Yanes clearly understands his position in all of these cases, and we would just ask that the court follow the plea bargain.
All right. Then in the cause number ending in 2928A, the court will find you guilty, sentence you to 16 years in the prison.
Now we begin seeing how investigators connect events across multiple days and locations, creating what prosecutors call a pattern of activity. One shooting leads to another. Surveillance footage leads to social media analysis. Social media leads to location tracking. Vehicles connect suspects. Warrants pile up. And suddenly, what seemed like isolated incidents appear linked through people, weapons, and movement patterns. Law enforcement increasingly uses digital trails, Instagram videos, and Cash App accounts, IP addresses, to build cases. Modern investigations are as much about data tracking as traditional detective work. For viewers, this part is important because it shows how quickly young suspects can get pulled into escalating violence once criminal activity begins. One bad decision leads to another, and soon law enforcement scrutiny intensifies. Here's something to consider. Do social media posts and online behavior make it easier for police to solve crimes today? Or are people just oversharing without realizing consequences? And the timeline is about to culminate in a dramatic chase and standoff that pulls multiple suspects, including Wilson, back into custody.
This is run concurrent with 2024 CR 2930, County Court Cause number 723230. Taking in consideration 2024 CR 2927A. And in that cause number, the court is finding, based upon your plea bargain agreement, that you acted in concert with Curtis Wilson, and there's an affirmative finding of deadly weapon. The court will give you credit for any time served. Anything else with regards to sentencing under that cause number?
No, ma'am.
And cause number ending in 2930, the court will find you guilty, sentence you to 16 years in the prison. There's an affirmative finding of deadly weapon. This will run concurrent with 2024 CR 2928. 723230, taking in consideration 2024 CR 2927A, and give you credit for any time served. Is there anything else with regards to sentencing in that cause number?
No, ma'am.
We can go off the record. How old are you?
20.
All right, you're 20. I know that's a lot of time. Any time that people do in custody, even if it's a day, it's a lot of time. But you still have a chance to improve your life. When you go to the prison, I understand that sometimes people will join organizations for their safety, but do not go to prison and become institutionalized. You have a chance, if you don't have your high school diploma, you have a chance to get your GED. You have a chance to get a college degree. You have a chance to get a trade, so when you come back out, you can change your life. You understand? And when you're released, if being in San Antonio is not helpful for you because of the people you surround yourself with, then leave.
2 shootings
You
in 2
understand?
days, followed by
This moment shows how quickly situations escalate once suspects are actively being pursued. Authorities attempt a traffic stop, suspects flee, vehicles crash, and a standoff follows. SWAT involvement signals law enforcement believes suspects may be armed or dangerous. From a legal standpoint, evading arrest, possession of stolen firearms, and involvement in shootings compound charges dramatically. Each incident stacks potential prison exposure higher. For Wilson, already facing serious charges, on being linked to further incidents worsens public perception and courtroom positioning. Judges reviewing bond, probation, or plea agreements factor in behavior patterns, not isolated mistakes. And viewers should recognize something. Once someone is connected to repeated violent incidents, courts shift focus from rehabilitation potential toward community safety. So let's ask, at what point should courts decide someone is too dangerous for leniency? After one incident? Or only after repeated offenses? Everything we've seen now brings us to the bigger picture, and what this entire courtroom saga ultimately means.